Supreme Court in the matter of VANASHAKTI versus Union of India struck down 2017 notification and the 2021 office memorandum as well as all circulars, orders, office memorandum notifications issued for giving effect to the notifications were considered illegal and were struck down. The court restrained the central government from issuing circulars or orders or office memorandum or notifications providing for grant of ex post facto environment clearance in any form or manner or for regularizing the acts done in contravention of the environment impact assessment notification. It clarified that the environmental clearances already granted till date under 2017 notification and 2021 office memorandum shall however remain unaffected. Court said that the Part 4A of the Constitution of India containing fundamental duties as set out in Article 51A was incorporated in the Constitution by the 42nd Amendment Act with effect from 3rd January 1977. Clause G of Article 51A provides that it shall be the duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. This court, in several decisions, has earlier held that right to live in a pollution-free environment is a part of fundamental right guaranteed under Article 21 of the Constitution of India. The world changed rapidly after World War II. From the late 1960s and early 1970s, slowly there was a realization about the drastic consequences of the destruction of environment and pollution of various kinds. In June 1972, at Stockholm, the United Nations Conference on Human Environment was held. In the said conference, several decisions were taken by world community to protect the environment. In our country, it took 14 years thereafter for the legislature to come out with a law for protection and improvement of the environment. The Environment Protection Act 1986 was brought into force with effect from 19th November 1986. As can be noticed from several orders of the Supreme Court and High Courts, the progress of implementation of 1986 Act has been very slow. The 1970s and 1980s saw growth of industrialization in our country. The activities such as mining, gas exploration, thermal power plants, petroleum refining industries, various other industries, building and construction projects such as highways started growing. Again, it took 20 years after the 1986 Act came into force to exercise the power under subsection 1 and clause 5 of subsection 2 of section 3 of the 1986 Act, read with clause D of subrule 3 of rule 5 of Environment Protection Rules 1986 for coming out with Environment Impact Assessment Notification 2006. The EIA notification was issued on 14 September 2006. It provided that the projects or activities mentioned in clause 2 thereof shall require prior environmental clearance from concerned regulatory authority. Concerned regulatory authority in central government is the Ministry of Environment, Forests and Climate Change for matters falling under category A in the schedule, and at the state level the State Environment Impact Assessment Authority for matters falling in category B. In the schedule, categories A and B were incorporated, setting out industries and other developmental work. The entire controversy in this group of petitions was about ex post facto grant of environment clearance. Court said we must remember that the 2021 Office Memorandum is applicable even to completed projects. The 2021 OM says that the grant of environmental clearance to such projects shall be effective from the date of issue. If project proponent goes ahead with construction which requires environmental clearance under Environment Impact Assessment Notification, it will amount to violation of provisions of 1986 Act and 1986 rules. It will attract penalty under Section 15 of 1986 Act. Perusal of provisions of Section 15 shows that even if the penalty is paid by the project proponent, it will not regularize the project. Therefore, even after payment of penalty, if the project is under construction, same has to be stopped and demolished. And even if operation has already commenced, the same has to be stopped and demolished. Therefore, the construction work has to be demolished. Now, we will take a case of ex post facto environment clearance provided under 2017 notification. The effect of grant of ex post facto clearance was that if without obtaining environment clearance, construction is in progress, same is allowed to continue. If construction is complete and operation processes are going on, same can go on after ex post facto environment clearance is granted. Effect of grant of environment clearance under clause 11 of 2021 OM will be grant of permission to complete construction of project though construction had commenced without prior environment clearance. Where construction is already complete, which is being used for processes etc., by grant of EC, process or activities can continue. Thus, in effect, EC granted under Clause 11 of 2021 OM regularizes something which was illegal with retrospective effect. In effect, EC granted under Clause 11 of 2021 OM will regularize illegality done by commencing construction or commencing project without prior EC. Therefore, in substance, what is provided in grant of ex post facto EC? In other words, what is granted is EC with retrospective effect as it regularizes illegality committed earlier. Grant of EC under 2021 OM no doubt is subject to making payment of compensation determined based on polluter pays principle and undertaking activities relating to remedial plan. Once there is violation of EIA notification, project proponent has to compensate following the polluter pays principle. Even if EC is not granted to him, he has to pay for remedial plan to remedy the damage done to environment. He has to pay penalty of section 15 of 1986 Act. Therefore, what is done by 2021 OM is something which was completely prohibited by the court in cases of common cause and alembic pharmaceuticals. It is an attempt to bring in an ex post facto or retrospective regime by craftily drafting the SOP. Grant of EC under 2021 OM in substance and effect amounts to ex post facto grant of EC. Court must come down very heavily on the attempt of central government to do something which is completely prohibited under the law. Cleverly, the words ex post facto have not been used, but without using those words, there is a provision to effectively grant ex post facto EC. The 2021 OM has been issued in violation of decisions of the court in the cases of common cause and alembic pharmaceuticals. 2021 Office Memorandum, which permits grant of environment clearance, is completely arbitrary and illegal, said the court. Moreover, 2021 Office Memorandum does not refer to exercise of any power under the 1986 Act or 1986 rules. Under Article 21 of Constitution of India, right to live in pollution-free environment is granted. In fact, 1986 Act has been enacted to give effect to this fundamental right. In 1977, fundamental duties of all citizens were incorporated in Constitution, which enjoined every citizen of India to protect and improve environment as provided in Clause G of Article 51A. Therefore, even central government has a duty to protect and improve the natural environment. Today, in the year 2025, we have been experiencing drastic consequences of large-scale destruction of environment on human lives in capital city of our country and many other cities. At least for span of 2 months every year, residents of Delhi suffocate due to air pollution. AQI level is either dangerous or very dangerous. They suffer in their health. The other leading cities are not far behind. Air and water pollution in cities is ever increasing. Therefore, coming out with measures such as 2021 Office Memorandum is violative of fundamental rights of all persons guaranteed under Article 21 to live in a pollution-free environment. It also infringes health right granted under Article 21 of Constitution. 2021 Office Memorandum talks about concept of development. Can there be development at the cost of environment? Asked the court. Conservation of environment and its improvement is an essential part of the concept of development. Therefore, going out of the way by issuing such office memorandums to protect those who have caused harm to environment has to be deprecated by the courts which are under a constitutional and statutory mandate to uphold the fundamental right under Article 21 and to protect the environment. In fact, courts should come down heavily on such attempts. As stated earlier, 2021 Office Memorandum deals with project proponents who were fully aware of the environment impact assessment notification and those who have taken conscious risks to flout the EIA notification and go ahead with the construction, continuation, and expansion of the projects. They have shown scant respect to the law and their duty to protect the environment. Apart from violation of Article 21, such action is completely arbitrary, which is violative of Article 14 of Constitution of India besides being violative of 1986 Act and the EIA notification. Court said that we are, however, conscious of the fact that ex post facto environment clearance may have been granted in certain cases both under the 2017 notification and the 2021 office memorandum. Environment clearances already granted under 2017 notification and 2021 office memorandum at this stage should not be disturbed, said the court.